May it please the court, I'm Janet Hayes. I'm here today on behalf of Knoxville HMA Physicians Management, and I'd like to reserve 4 minutes for rebuttal, please. Knoxville HMA Physicians Management operates through a subsidiary, a hospital. It is a hospital that at times pertinent to this case had multiple campuses. The 3 campuses the court may be familiar with were known as Physicians Regional, Turkey Creek, and North Knoxville. The issue before the court is the interpretation of the term hospital as used in the plaintiff's employment agreement. More specifically, the issue is whether the parties intended for the term hospital to be the singular hospital HMA that operates 3 campuses. Pertinent.
Was the definition of hospital listed in the contract?
The contract, we have to look at the contract as a whole, and obviously that is going to be my argument. On the cover page of the contract, which is where the issues really arise in this case, the term hospital, next to it, it said Physicians Regional Medical Center. This, if I may back up, this employment agreement that the plaintiff entered into was to provide services as a nurse midwife. The services the employment agreement provided, the purpose was to ensure sufficient medical services available to serve the community. Plaintiff was represented by counsel and negotiated certain terms in the employment agreement. One of the terms that was not negotiated was Section 5.4 that offered up 4 potential, what I'll call triggering events, that if any one of these events occurred, the plaintiff would be entitled to 2 months' pay. One of the events was the cessation of material operations of the hospital. In 2018, the plaintiff received a notice that physicians, and the notice stated, the Physicians Regional Medical Center location would be closing. Based on that notice, she did not stay and see what happened when it closed or attempt to relocate to one of the other campuses. Instead, she voluntarily quit her employment and tried to invoke Section 5.4 and claimed that she was entitled then to 2 months' pay. That led to litigation, and there were other issues in the trial court, but the only issue that is being appealed, both sides filed motions for summary judgment on this issue in the trial court, and ultimately the trial court granted the plaintiff's motion for summary judgment. Now, both sides will argue today some very fundamental principles of contract interpretation. What we are here to do is to try to determine the intent of the parties at that time when they entered into this employment agreement. And we submit, if you look at the...
You have 3 campuses. One closes, the other 2 are still operating. Plaintiff is employed or works at one campus, the one that closes. Okay. Now, in order for her to be subject to or qualify for this 3 month, was it 3 months? 2 months salary. Would all 3 of the campuses have to close? The whole thing has to shut down?
Correct. In the employment agreement, what it provided was if the hospital closed, if the hospital ceased operations.
But she was not guaranteed employment at the other 2 campuses that remain open.
That's correct.
The one she was at closed. In fact, the notice provided to her says that she can seek employment, but it's no guarantee she's going to get there.
That is correct. She could seek employment at one of the other campuses. It wasn't guaranteed, but she could seek to get a job at one of the other campuses. But the fact remains, those were 3 campuses of one hospital. They were simply 3 separate locations. Right. And if you look at...
Is it your position then that that contract provision, termination without cause, isn't applicable here?
I'm sorry, I couldn't.
That the termination without cause provision is not applicable because all 3 campuses didn't close?
Correct.
What was their basis for firing her without cause?
She was not fired without cause. She voluntarily quit. When she received notice that Physicians Regional Medical Center location was closing,
Will
then she
have
turned
their-
in a voluntary notice
I'm
that she
sorry,
was
will have
quitting.
their employment permanently terminated on December 28?
She didn't, she quit before we got to that point.
Well, they
But-
sent-
but
they
she-
sent the
yes,
notice,
I think
didn't
to
they?
your point, she did receive notice that the physician's
Okay.
regional location, she worked in the medical office of a doctor.
So she was told she was going to be terminated as of December 28.
Correct. Correct. The
And I'm
contract, if
okay,
you
well, so
look at
what was your
her,
basis, what was the basis for firing her without cause?
the,
If this contract provision doesn't apply,
right. I
what
don't
was
think
the
the
basis?
issue is
Why
whether,
could they fire her without cause when they had a specific termination without cause provision?
I think it could be likened to a reduction in force. There was a closure of a campus. There
I-
was one entity
Okay.
that,
But your all's view is that it's all one deal.
correct. It is one hospital. It is one hospital that operates
So,
at
but if
3
one
different
campus
locations.
closes, you could fire without cause.
We are just asking to implement the terms of the contract as it's written, and that section 5.4, that particular trigger is only invoked if the hospital ceases operations.
Well, if that clause doesn't apply, what contractual basis did your client have to fire her?
Your Honor, the hospital, the campus, I guess you could
Well, I understand
treat
why,
it as a
I
reduction in
understand
force.
why they did. But you're saying this contract provision only applies if all 3 campuses close. So if you have a contract that has a termination without cause provision, and what happens doesn't fit under that contract, what's your client's legal basis for firing her?
I think you're asking
I'm not
me to
asking why, I
rewrite.
understand why they fired her, because the campus closed.
Right.
What's the legal basis for firing her? You have a termination without cause, I keep saying clause, termination without cause provision, but your client's position is that clause does not apply.
Correct.
All right,
That provision does not apply. I guess the same question would be if all 3 locations closed.
Well, then my question would be, if that clause doesn't apply, what was the legal basis for firing her? I understand why they did, but what's the legal basis for firing her without cause?
I don't know that there is an issue about with cause or without cause. Her
Well, what's the
employment
legal
was-
basis for firing her?
Right.
Assuming she was fired, and I understand your position that she resigned before.
Right. She was resigned. We don't know if she would have been fired, and she certainly would have had the opportunity to go to work as many other people did at
She
one
would
of
have had
the
the
other
opportunity
campuses.
to apply pretty much the way any nurse would,
Correct. Correct.
but they worked for.
I think at the time
All right,
the parties.
I'm just trying to figure out if that clause doesn't apply, and you all have provided in a contract, here's when you can be fired without cause, and what happened doesn't fit there, what's the legal basis for being able to fire her?
I understand, Your Honor.
Okay.
The legal basis is what we have already discussed. There was a reduction in force. There were no jobs available at that campus. There continue to be other jobs available, and we simply do not know. We did not make it to the point, I guess, of her actually being fired. That didn't happen, and perhaps this would be different if we had gotten to December 28th. Then she may have been terminated, but in this particular case, she was not terminated. She was given notice that something was going to happen in the future, and she voluntarily quit. I think with regard to the issue of, which the real issue is the hospital. Is the hospital a 3-campus system, or is it one entity? And
Excuse me for interrupting, counsel. On that point, as I understand, the cover sheet identified the employer as Knoxville HMA Physician Management and identified the hospital as Physicians Regional Medical Center.
yes,
And the applicable section of this agreement is cessation of all material operations of the employer and or the hospital. How is that reconciled?
Physicians Regional Medical Center is simply an assumed name of HMA. Physicians Regional Medical Center has no assets. It doesn't exist. It doesn't have a legal identity other than
Is that
as
part of the
HMA.
contract? Is that part of the contract? Does it address assumed names?
It does not address assumed names, but I would point out the contract does reference specifically the HMA bylaws and incorporates the HMA bylaws into the terms of the contract. If you look at the HMA bylaws, which would be a term of this contract, they say that the 3 geographically separated campuses are, and I quote, considered as one hospital with a single medical staff operating under one set of bylaws and rules and regulations. So the employment agreement that she signed incorporated these bylaws, and this is the most definitive statement we have on the issue. And the bylaws specifically say the 3 campuses are one hospital with a single medical staff operating under one set of bylaws, rules, and regulations. And if you look at the other provisions of the agreement, if you go through it and look at all the references to the term hospital throughout the agreement, if you adopted the plaintiff's argument that all those mean Physicians Regional, then those provisions often would be rendered nonsensical. For example, there's a provision that that same section 5.4, if either party terminates the agreement, they can terminate upon transfer of, quote, the hospital's assets. Well, Physicians Regional had no assets. Of course, it means the hospital in a broader sense. Similarly, the bylaws, or in the employment agreement, it repeatedly references the hospital's bylaws and hospital's board. Physicians Regional did not have bylaws. They did not have a board. So if you look at the entire contract and not one provision in isolation, it is clear that what the parties intended when they entered into the agreement was that hospital be a 3-campus system. As I'm out of time, I will, unless you have further questions, seek the floor.
You have your time for rebuttal. Hear from the appellee.
May it please the court, my name is James Stovall. I represent the appellee Manola McCain. The parties do agree, I think, on one thing, and that is that the issue, the sole issue on this appeal is how to interpret a specific definition in Ms. McCain's employment agreement. And Judge Frierson, you were just asking my friend about that. Hospital in this agreement, and this is important, hospital with a capital H is a defined term, and section 1.1 of the contract says that capitalized terms shall have the meaning set forth on the cover sheet. So the case is really that simple. In a way, this is a case about case, as in uppercase or lowercase. The uppercase term hospital means Physicians Regional Medical Center. That's what the contract says. Contracts are enforced according to their plain terms. HMA is a sophisticated corporation. This contract was a form contract that it used with all its certified nurse midwives. The cover sheet is how it told those midwives what hospital they were going to be working in. It was HMA that chose to define hospital as Physicians Regional Medical Center. It made that decision. When a sophisticated party defines a term, that's the definition that's going to control, not some other definition. So, what about the bylaws? Let's talk about the bylaws. Yes, the bylaws were incorporated by reference. We urge the court to consider the bylaws. The statement that HMA is relying on about the 3 locations being considered one hospital, that's a small h hospital. That's a different document. It's not even in conflict with the defined term in Ms. McCain's agreement. It doesn't purport to override the definition in the contract. And hospital in the bylaws is not a defined term. So yes, there is a passing reference to the 3 locations being considered as one hospital, but that doesn't mean they're one hospital for all purposes. It doesn't mean that HMA can ignore the definition that it chose. So the 3 campuses, and what are we talking about when we say campus? We're talking about hospitals. Physicians Regional Medical Center is the hospital.
Well, what do you say, the opposing counsel's argument there that, look, a lot of this clause simply doesn't make sense if it talks about transfer of all or materially all of employer and hospital's assets to, they say the physician regional doesn't have any assets.
It doesn't say. I think that, first, it's important to note that even in that clause, or especially in that clause, it's hospital with a capital H, not hospital with lowercase h.
But it has no assets, according, as I understand the proof was.
Two points about that. This provision doesn't say assets owned by Physicians Regional. I think the way to harmonize, to read the contract as a whole, that provision, it's not nonsense, it's not absurd. Of course there were assets at Physicians Regional. There were hospital beds, lab equipment, surgical equipment, and if those assets were transferred, that would trigger this provision. That would trigger the assets provision. Your Honor, Chief Judge, look at C, 5.4C. That's the specific provision that Ms. McCain invoked her right to resign, terminate without cause. 5.4C says cessation of all material operations of employer and or hospital. So that's the provision that's at issue in this case. Cessation of material operations. The operations at Physicians Regional did cease. They did cease, and you don't have to just take my characterization on that point. HMA itself used that very language in the notice that was given to Ms. McCain. That notice that Judge McClarity already asked about, which is in the record, page 384 in the record, it says, please note that all operations at our Physicians Regional Medical Center location will permanently cease. It uses the very language in the termination provision, and that's HMA's own form. None of this is absurd. Yes, it had assets. Yes, its operations could cease. And HMA had good reason to define hospital. To put it simply, Ms. McCain needed to know where to deliver babies. This agreement requires her to admit patients at hospital with a capital H. It requires her to provide on-call coverage at hospital with a capital H. If not for the cover sheet, she wouldn't know which of the hospital campuses to send the patient to. So HMA had good reason for this definition. She delivered babies, she admitted patients, as required by her contract, at the hospital known as Physicians Regional Medical Center. The fact that it was a hospital, the 3 campuses did have one state ID number. So they were a hospital, one hospital for that purpose. That doesn't mean that they still weren't separate hospitals. And HMA knows this. At the deposition of their corporate rep, Tyler Sherrill, he was asked, Mr. Sherrill, you understand what I mean by Physicians Regional Medical Center, do you? And he said without hesitation, the hospital in downtown Knoxville, people still call it St. Mary's. That's what we're talking about, St. Mary's. So this, the argument here, not only does it conflict with the plain language, it conflicts with the way HMA itself used these names. So let's talk about the bylaws. They don't define hospital. They don't trump the definition in the contract. Yes, Physicians Regional had bylaws. They had one set of bylaws. That doesn't mean that all three hospitals, all 3 campuses, that doesn't mean they didn't have bylaws. HMA's argued on appeal, well, they didn't have an independent set of bylaws. So, it had bylaws. And those bylaws treat the operations at the different campuses distinctly. In the bylaws themselves, 2 examples. Medical providers had to apply for admission to staff at each campus. So if these terms, what HMA has argued on appeal is, well, this is an assumed name, you got to treat them as interchangeable. That has never been the case in HMA's practice. That has never been the case. Doctors and other medical providers had to apply for privileges at each campus. And you could have separate practice status, different status at different campuses. That's one example. Also, each campus had its own CEO, CFO, and chief nursing officer. So HMA itself did not use the names of these locations interchangeably. There is no evidence in the record that HMA ever used the term Physicians Regional, the name Physicians Regional Medical Center, to refer to anything else but the hospital that many of us know as St. Mary's. That's the location we're talking about. HMA itself used that name for one location and one location only. And HMA itself chose to use that name to define hospital with a capital H in this agreement. Board of directors, another argument that HMA has made is that Physicians Regional didn't have a board of directors. Well, it did. All 3 campuses had a board of directors. One board for all 3 campuses. And the board, and this is defined in the bylaws, the board is specifically defined as the advisory board of Physicians Regional Medical Center. It's referred to in the bylaws. Similar point, again, how HMA itself used these names. The contract required Ms. McCain to get medical and staff practice privileges at all locations. So, in accordance with her contractual obligation, she would submit application forms prepared by Tenova or HMA, and she had to separately check where was she applying. Physicians Regional, Turkey Creek, North Knoxville. Separate check for each one. And when HMA approved her application, they did so by letters that were signed by each CEO with a separate signature block for each location, for each hospital campus. A CEO for Physicians Regional, for North Knoxville, for Turkey Creek. The point is that HMA itself never used one location name to refer to a different location. It never did. Not in the contract itself, and not in the documents that the parties used when they were performing their obligations under the contract. One more point on the assumed name. The fact that a company has an assumed name does not mean that if it has more than one assumed name, the names are interchangeable. That's not what the assumed name statute is about. You know, that statute applies if someone's trying to hold a member or owner personally liable for an obligation of the LLC. And let's say they were operating under a DBA or assumed name, they get sued personally. They say, well, no, wait a minute. That was LLC. We were doing business as an LLC and we have a registered assumed name. The point is that using a DBA or an assumed name doesn't strip a member or owner of that liability protection. But that protection has nothing to do with the way that an entity with multiple assumed names can choose to use those names. This isn't about trying to pierce the veil and hold the members of Metro Knoxville HMA LLC personally liable. So the fact that it was an assumed name has no legal significance in this appeal, none whatsoever. It would be as if Copper Cellar Corporation hired somebody to work at Chesapeake's. Assumed name. That person can't say, oh, Chesapeake's is an assumed name. Oh, I want to work at Calhoun's as well. Assumed names don't work that way. That's not the way that HMA used them. So our position is that when the contract is considered as a whole, including its definitions and its capitalized terms, and by all means, including the bylaws, when it is considered as a whole, it's clear that the definition of hospital as Physicians Regional means the hospital location, known as Physicians Regional, which used to be called St. Mary's. The trial court's judgment awarding 2-month severance should be affirmed. Thank you.
Thank you. Hear from the appellant rebuttal.
Your Honor, just a few points. We've heard a lot of argument about separate locations, and we certainly don't dispute that there are separate locations. The issue in this case is not whether there are multiple locations. Of course there are, but multiple locations does not mean there are multiple hospitals. And as counsel said a few times during argument, Physicians Regional, that's the location we're talking about. We don't dispute that Physicians Regional is a location of the hospital. That does not mean that Physicians Regional, by the terms of this contract, when you read it in its entirety, is the hospital. It is simply one campus, one location of the hospital. Ms. McCain has mentioned the cover sheet, and the trial court made a significant issue about the cover sheet. I would just like to note that the cover sheet is simply one part, and as we've said, the cover sheet lists Physicians Regional, which was an assumed name, and I do think there is a legal relevancy to an assumed name here. The assumed name is of the hospital, HMA. The fact that different campuses used different assumed names is irrelevant. It doesn't matter. You don't have to interchangeably use Physicians Regional and Turkey Creek. That doesn't mean that Physicians Regional is not HMA or that Turkey Creek is not HMA. But more importantly, with regard to the cover sheet, there is a provision in the employment agreement that says where the terms of the cover sheet, this is section 1.1, where the terms of the cover sheet conflict with the agreement, the terms of the agreement prevail. So I think we have to look at the entire body of the agreement and what the parties intended. When you try to get at what the parties intended, then you have to look at all of the facts and circumstances. And I agree, it is of significance to look at the notice that was given to Ms. McCain. The notice did not say there would be a cessation of operations of the hospital. The notice said there would be a closure of the Physicians Regional Medical Center location of the hospital. Also, there's been some discussion about privileges. I think it is important to note that Ms. McCain applied for, and this is in the briefing, she had privileges at different campuses. That doesn't mean the different campuses were different hospitals, but she did have privileges. So when one campus closed, she kept her privileges at the other campuses, and perhaps more importantly, her employing physician, she worked for Dr. Brabson, and Dr. Brabson, in his statement, the employing physician statement, said that he would be responsible for her actions at all of the campuses and lists the different campuses. Now, I don't pretend to know where she actually did work, but she agreed when she entered into this employment agreement that she would be working at all of the campuses, and Dr. Brabson affirmed that she would be responsible for patients at all of the campuses. Finally, there was reference to the bylaws, and I guess we do agree the bylaws are instructive. We just disagree as to the conclusion that should be drawn from the bylaws. If you look at the bylaws, in one provision, I'll use this for an example, if you look at all the references in the bylaws to hospital. And instead of us using the word hospital, accepted counsel's argument and used the term physicians regional. The bylaws say that the individual must maintain a staff category at each campus location. It does not say at each hospital. If plaintiff's argument were correct, it would say, the bylaws would say hospital. The bylaws require that different committees be formed and that the committees include members from, quote, each campus location. It does not say committee members from each hospital. The bylaws say physicians may have a different status at each campus location. The bylaws do not say a different status at each hospital. And for those reasons, we ask that the court look at the entire agreement, and given the entire agreement, consider what did these parties intend when they entered into this employment agreement. And it is very clear that they intended that hospital be a 3-campus system as they knew and understood it to be. For those reasons, we ask that the court reverse the decision of the trial court.
Our thanks to counsel for both sides for your briefs and your oral arguments.